For patience.
Six courtrooms and another meeting room. This is child's play.
Ah, well, I mean, pretty easy for you to say.
We're live. You guys can begin.
Thank you.
Thanks. I'm not seeing anybody though.
I'm sure they see you. You'll have to unmute some people when they start speaking. They'll probably start showing up. Or
Okay.
if they're on a phone, we're only going to hear them instead of see them.
Yeah, for our participants, can you unmute yourself and turn your video feeds on?
Ah, there. Yay.
There we go.
Okay. A few more, so.
Yeah, there's quite a few there, Brian, or Guy.
Yeah, I see him.
Okay.
Should we wait for the others? It says there's Michael, Garrett, and Allie to join. So.
Several of those are coaches, I believe, Your Honor.
Okay, thanks. This is I won't officially start the trial yet because I just want to make sure everything's right. So everybody can see me. I can see you. Are there any preliminary before I officially start the trial? People can see me. I assume they can hear me. I'm glad I don't have a cat face, so that part's good. I guess we're okay to start, right?
I think so.
Okay. I don't have a bailiff, so we'll start. The court will come to order. Let's start it. Is each side ready for trial?
Yes, Your Honor.
Yes, Your Honor.
Okay. Normally, this is the first time I've done this with Zoom. Normally we're in a courtroom, and I think there's the preliminary matters I usually have to go through live. Let me just go through the list that I would if this wasn't a Zoom. Has each I'm supposed to be provided, and the scoring judge is supposed to be provided with copies of the team roster. How are we doing that this year since we're on Zoom?
I can screen share our team roster if you would like, Your Honor.
Okay, I think Mr. Nolan, I'm the presiding judge. Mr. Nolan is the scoring judge, so I think he's going to need that. So can you get that to him somehow? Can each side get that to him?
You know, what would really help me as I work through the score sheet is during each segment, have the students introduce themselves again. And I will mark their names on the score sheet, this electronic score sheet that we're dealing with. Although, frankly, I'm looking at the score sheet right now. Okay.
Yeah, you need, yes. Actually, you need first, let's take this a step at a time before we start. We need the team code. So the plaintiff, what is your team code?
Your Honor, I believe it is 12.
Okay.
12?
You have, and the team code for the defense, who is that, or what is that number?
Ours is number 4, Your Honor.
Number
Okay,
4.
thank you.
Thank you.
So Mr. Nolan, I think the easiest thing is when we start each round, the opening and each
Right.
witness, we'll just have them identify their name and then you can enter that in.
I think that
work?
will help.
Okay. Now, well, let me go through the rules. Now, normally there's a gallery and I have instructions for the gallery, but I don't think we need to do that. I'll remind the teams that no recesses will be allowed with the exception of a health emergency. And I'll direct this to Mr. Nolan as a scoring panelist. Does he have any reason to be biased by judging either team? And I would ask Mr. Nolan if he recognizes or is familiar with any of the parties or participants on the screen.
I do not. I don't recognize anyone.
Okay. I remind the teams and coaches that any disputes arising out of this competition must be reported in accordance with the rules. I'll remind the teams that their compliance with time requirements will be considered in scoring individual performances. Well, I'd ask well, the instructions say ask each side to introduce the participating team members. I think we're going to do that with each witness.
Step by step, right.
Yeah, that's better. So for now, we need to do the swearing in and then we'll start. So I'd ask all members, participants in the courtroom, normally you'd stand, but it's Zoom. It's fine if you sit here, but if you'd raise your right hands, and I'll say, oh, please raise your right hands. And team members, do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? You're on mute. I assume everybody answered yes. That'll be an affirmative. I saw head nods. Witnesses, can you raise your right hands? Do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock court trial competition? Okay, I saw affirmative nods from everybody. Are there any gallery members? If there are, let me do that. Gallery members, teachers, and attorney, coaches, family members, and friends. If you could all raise your right hands. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? And I think that was an affirmative from that. And then scoring panelists, please, Mr. Nolan, could you please raise your right hand?
Yes.
Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
Okay, with that, let's begin the trial. The trial will come to order. Is each side ready to proceed?
Yes, Your Honor.
Okay, if
Yes, Your Honor.
if we have an plaintiff, could have entries of appearance for the plaintiff and identify witnesses, please.
Good morning, Your Honor. Ladies and gentlemen of the jury, opposing counsel, my name is Jacob Durso, and today I will be delivering the opening statement on behalf of the prosecution, conducting the direct examination of Jordan Markowitz, as well as the cross-examination of Blake Van Owen.
Good morning, Your Honor.
Go ahead.
Opposing counsel and members of the jury, I am Joanna Flores Chavez, and I will be performing the direct examination of Kyle Kozak and the cross-examination of Taylor Perkins.
Thank you. Do we have, before opening arguments, do the parties have any stipulations or any preliminary matters before opening statement?
Yes, Your Honor.
Proceed.
do we.
Okay, let's address those preliminary matters. So plaintiff or Mr. Durso?
Your Honor, we have 5 preliminary matters. For each of them, actually, I would say we have 7 preliminary matters. For each of them, we ask for the court's instruction on behalf of both the prosecution and the defense.
Okay, well, go ahead and address the matters and go.
Firstly, if at any time the court cannot see or hear a lawyer who is speaking, a witness who is testifying, or an exhibit being displayed, we ask that the court interrupt so he or she can solve the problem.
That's fine. Yes, I agree with that. I smiled a little because as an attorney, I'm not as proficient as the Zoom, but I'll interrupt if there are any problems on our side. So that will be granted.
Also, we ask that if technical difficulties stop the trial for more than 20 to 30 seconds, we ask that the court direct the timers to stop the clock until the trial can proceed.
Defense have any comment on that?
That's fine with us, Your Honor. Thank you.
I agree, and that's granted.
Next, we ask that when the prosecution has a witness identify the defendant, may we ask that the defendant turn on his or her camera for the purpose of identification?
Defense have a response to that?
That's fine with us, Your Honor.
That will be granted and ordered.
Under Competition Rule 7.4, a team may screen share an exhibit when seeking admission to the exhibit. The rule provides that a screen shared exhibit will be deemed not to have been shown to the jury unless admitted as evidence. How would the court like the teams to proceed when seeking admission of an exhibit?
I think procedurally, I assume when you screen share an exhibit, Mr. Nolan and I will be able to see it. For those purposes, as long as I can see it and Mr. Nolan can see it on a screen share, that I'm fine with that, and then you can address the document and its admissibility at that point.
Okay, proceeding. Under Competition Rule 7.4 and 4.7, a team may use Zoom annotation features to mark exhibits electronically. Once an exhibit is admitted, would the court like us to ask permission to mark the exhibit?
I'd like to keep this moving. I want I'd like each side to move for admissibility. If it's not stipulated that an exhibit is admissible, I'd like each side to move for its admission, and then I'll make that determination. And at that point, that would be fine. I don't think we need to take the time to then present that to the jury.
All right. Lastly, we just ask that any remaining time on closings be saved for a rebuttal, and that previously admitted evidence can be used in closings.
Yes, that's acceptable. So, does the defense have any preliminary matters?
Yes, Your Honor. First, we ask that everything that has been granted to the prosecution be granted to the defense as well.
That was my intent, yes.
And then second, Your Honor, we would ask to screen share as a way to publish to the jury and do that immediately after an exhibit has been admitted without having to ask further permission.
Yes, I agree with that.
And finally, Your Honor, we request that the stipulated facts be received into evidence.
What's plaintiff's position on that?
That is good with us, Your Honor.
The stipulated facts are admitted into evidence.
Nothing further, Your Honor.
With those preliminary matters out of the way, oh, and one other thing, I'm going to make, let me make the parties aware of one other thing. I'm in my office, and outside the window, starting yesterday, they started doing some construction and putting new siding and insulation on the building. I think they're done, but yesterday afternoon, there was all kinds of pounding. I'm really hoping that doesn't happen. If it becomes a problem, I'd ask the parties to let me know and I can move to another interior room. With those preliminary matters out of the way, does the, let's proceed to opening statements. Calling the plaintiff. Oh, I'm sorry, go ahead.
May the defense make their appearances?
Your Honor.
Okay, I thought we had, or I had, but if that was my mistake, go. I thought we had appearances from the plaintiff already, but yeah, my mistake for the defense. Please enter your appearance.
Your Honor, prior to the defense beginning their appearances, may the prosecution finish theirs?
That's fine. Yes, it's much harder on Zoom. I apologize for that. So let's have entries of appearance from on all the plaintiff's side.
Thank you, Your Honor. Good morning, Your Honor, opposing counsel and members of the jury. My name is Marian Damtu, and today I will be conducting the direct of Alex Cifuentes, the cross-examination of Avery Becker, and I will also be delivering the closing on behalf of the prosecution. Your Honor, at this time, may our witnesses now introduce themselves?
Yes.
Good morning, Your Honor, members of the jury. My name is Ella Thomas, and today I am Alex Cifuentes.
Good morning,
Thank
Your
you.
Honor. Good morning, Your Honor, members of the jury. My name is Milo Lamas, and today I am Kyle Kuzak.
Thank you. I thought number 12, Kate, I saw her. Is there another witness? I thought there were 3 witnesses. It looks like number 12, Kate, is trying to speak. Maybe your volume's off. Well, let's, I think that was the last witness. I couldn't hear Ms. Scheringer, but hopefully we'll have that fixed by the time she's called. So let's proceed on to the defense side. Can I have entries of appearance, please?
Yes, Your Honor. Good morning, Your Honor, opposing counsel, members of the jury. My name is Clara Ann Wind, and today I and my co-counsel represent Avery Becker. Today, I will be giving the closing argument as well as conducting the direct examination of Avery Becker and the cross-examination of Kyle Kuzak. May my co-counsel introduce themselves?
Yes.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Rachel Kidder, and today I will be giving the opening statement as well as conducting the direct examination of Professor Blake Van Owen and the cross-examination of Detective Jordan Markowitz.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Landon Stuckey, and I will be conducting the direct examination of Taylor Perkins and the cross-examination of Alex Cifuentes. May our client and witnesses introduce themselves?
Yes.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Logan Holtzinger, and I am Blake Van Owen.
Thank
Good morning,
you.
Your Honor, opposing counsel, members of the jury. My name is Shiloh Stuckey, and I am Taylor Perkins.
Thank you.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Melanie Mulcahy, and I am Avery Becker.
Thank you. One last procedural question, if either the lead plaintiff or defense counsel could let me know. I know you have timers, but how do I see the timer, or Mr. Nolan and I see the timer on our screen? Or how do I monitor that?
Your Honor, I believe our timer will be giving the times in the chat, as well as for like the last 10 seconds be showing up on the screen to give a visual representation.
Okay, thank you. If I want to access that, do I just click the chat button at the bottom?
Yes, Your Honor.
Thank you. Okay, let's proceed with the trial. Can we have opening statements first for the plaintiff?
Desperation, location, confrontation. Avery Becker was really good at mock trial, award-winning good. Today, you will hear that Becker, a participant in Colorado High School's mock trial team, became extremely angry at the victim, mock trial coach Mackenzie Brackman, after first being kicked off the mock trials A team and in turn the mock trial team as a whole. Avery Becker was so angry and desperate to take revenge on Brackman that even after vandalizing the coach's beloved vehicle, Becker proceeded to get back at the victim. The evidence will show that in early March 2020, Avery Becker told her mom that she would get back at Coach Brackman if, and I quote, "it is the last thing I do." You will hear today that on March 6th, 2020, Avery does just that, unlawfully entering Brackman's residence. In the midst of vandalizing the residence, Becker is surprised by Brackman himself, and in the following conclusion, hastily proceeds to stab the victim with a kitchen knife and leave him to lie in the doorway of his own home. The defendant today is charged with both second-degree burglary and first-degree felony murder. To prove burglary, we will show you that Avery Becker unlawfully entered Coach Brackman's residence with the intent to damage property. To prove felony murder, we will show that during this burglary, Coach Brackman died. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all the elements necessary to constitute the crime charged. We will meet this burden of proof today because we will show you, first, the desperation of the defendant to get revenge on Coach Brackman. Second, the confrontation between the defendant and the victim in which this crime occurred. And finally, prove that Avery Becker was at the location of the crime at the time of the crime on the day of the crime. Desperation. Today, you will hear from fellow and former student and mock trial team member Alex Cifuentes. Alex will testify to the rocky and spiraling relationship between Avery Becker and the victim, Mackenzie Brackman. Cifuentes will further testify through numerous text exchanges just how desperate Avery was to get back at Brackman at any cost. Confrontation. Ladies and gentlemen of the jury, today you will hear about the savage confrontation between the defendant and the victim at the victim's residence from crime scene reconstruction expert Kyle Kuzak. You will hear how this burglary gone wrong resulted in the death of a human being and how numerous pieces of evidence pointing towards the defendant being the bringer of death were found at the scene of the crime. Most notably, a Ring doorbell video in which the defendant matches the exact same height and build as the defendant. Location. Finally, you will hear today from detective and expert in phone data, Jordan Markowitz. Markowitz will definitively place the defendant at the scene of the crime using cell phone data from Avery Becker's phone. You will hear how at the date and time of the crime, the defendant's phone was cited at being in the very vicinity of the house where the defendant was killed. At the end of this trial, my co-counsel, Maren Damtu, will stand before you and remind you of the defendant's desperation for her confrontation with the victim and the evidence that shows the defendant's location at the time of the murder. She will ask you, the jury to find the defendant Avery Becker guilty of second-degree burglary and first-degree felony murder.
Thank you. Between each segment, I'm going to wait for Mr. Nolan to complete his scoring. So, Mr. Nolan, if you could just let me know when you're completed.
I'm ready.
Okay. Can we have opening statements for the defendant, please?
Yes, Your Honor. Don't judge a book by its cover. That applies to this case, too. The prosecution just showed you a book with an interesting cover. A high school mock trial coach murdered by an upset team member. However, at this trial, we will open that book for you and show you that the pages are garbled and illegible because the evidence does not support the cover. The title of this book should be, "We Have to Blame Someone." However, members of the jury, that is never a reason to charge an innocent person with murder. Good morning, members of the jury. My name is Rachel Kidder, and I, along with my co-counsel, represent Avery Becker, a college student who's been falsely accused based on inaccurate evidence from an incomplete investigation by an incompetent detective. By the end of this case, you will be able to see just how bad the story under the cover is. Today, you will hear about Mackenzie Brackman's death, but you will hear nothing of my client's involvement because she did not kill Mr. Brackman. And the person who might have committed this crime was never even investigated by the police. Mackenzie Brackman was found deceased in his home on March 6th, 2020. He was a criminal defense attorney and a volunteer mock trial coach. The police almost immediately focused the investigation on a high school student on Mr. Brackman's mock trial team, our client Avery Becker. She'd been kicked off the team, and the police believe that that's enough motive for murder. The lead they refused to follow, the pages of this book that would have made it fact and not fiction, pointed not to our client, but to someone who had a real motive to harm Mr. Brackman. As the judge will instruct you at the end of this case, it's the prosecution that has the burden of proving beyond a reasonable doubt that Avery Becker committed second-degree burglary and first-degree murder. Beyond a reasonable doubt, members of the jury, let that sink in. By the end of this case, to decide my client is guilty, you must not have a single reasonable doubt about any of the elements of either of these crimes. We believe the prosecution cannot meet this burden. We will open the book for you today and show you what's missing. What's missing is Avery Becker, who was never at the scene of the crime, and during the murder was miles away with her friend. The evidence will show that Mr. Brackman and our client did not like each other. We acknowledge they didn't have a good relationship, but that is a far cry from being willing to murder. Mr. Brackman and our client had a falling out after a mock trial practice. Avery Becker accidentally caused permanent damage to Mr. Brackman's car. She then went to his office, offered to pay for the damage to the car, and attempted to apologize to him, not to harm him. The prosecution will tell you she was really planning on vandalizing his house. Members of the jury, we will show you this is not true. But the most important fact is that during the murder, Avery Becker was with her friend miles away from the home. There will be no evidence she's ever even been to his home before. We will first call Professor Blake Van Owen, an expert in criminal investigations, who will testify that the police chose the desired outcome before the investigation started, rushed the investigation they actually conducted, and didn't even look into someone with much greater motive. This person was full of rage and wanted revenge because Mr. Brackman lost the criminal case that sent their father to prison for life on the charge of murder. The police never considered this person during their investigation. Next, we will call Taylor Perkins, who will testify she was with Ms. Becker the entire day of the murder. Their stories will match down to the minute. Prosecution tried to tell you that there's no evidence for this alibi, but what they failed to tell you is that there's no evidence because the police never investigated it. And finally, we will call our client Avery Becker. She will testify to her poor relationship with Mr. Brackman, and she will admit to her mistakes. However, she will also testify that she had no desire to harm Mr. Brackman, and she was with Taylor Perkins the entire day of the murder. She will testify her phone was stolen the day prior to the murder, and any messages or cell phone data coming from that phone did not come from our client. The prosecution, on the other hand, will call the detective whose rushed investigation accused the wrong person, the person who stole our client's cell phone, and a crime scene reconstructionist whose testimony about cell phones is so contradictory, you won't know what to believe by the end of his testimony. Members of the jury, After you've heard this case, we believe you will agree. The police did not investigate the right person, and Avery Becker had nothing to do with this crime. That is why at the end of this case, we will ask you to find the defendant not guilty of murder and expose this case for what it really is. Just another pretty cover. Thank you.
Thank you. Mr. Nolan, let me know when you're ready.
I'm ready, Your Honor. For the first witness, I'd like to get the names of plaintiff and defense counsel and the name of the witness.
Thank you. Could plaintiff call your first witness and initially identify that name, that witness?
Yes, Your Honor. At this time, I, Marion Damtu, would like to call Ella Thomas, who is playing Alex Cifuentes, to the stand.
Okay.
Please proceed.
Could you please introduce yourself to the jury?
Alex Cifuentes.
And Ms. Cifuentes, are you in school?
Yes, I'm a senior at Colorado High School, and I'm on the mock trial team there.
Do you know Avery Becker?
Yes, Avery was one of my teammates on the mock trial team.
And did you know Mackenzie Brackman?
Yes, Mr. Brackman was our coach.
Do we have a video of the witness?
Yes, it's number 12 at the top, Ella Thomas. Do you see it?
Let me find her.
She's at the top on my screen. I see her fine.
And her name is what?
Ella Thomas, it says on the screen.
Ella Thomas. Give me a minute. I need to find her.
Okay. I'm keeping track of time. There won't be prejudice to anybody, to either side.
There she is. There's Ella. Okay, I'm ready to proceed. Thank you.
Okay. Thank you. For timekeeper purposes, that took about 50 seconds. So please add 50 seconds to this witness's plaintiff's allotted time. Thank you. Please proceed.
All right.
Thank you, Your Honor. Ms. Cifuentes, were you ever able to observe Mr. Brackman and Ms. Becker interacting?
Yes, I saw them interact every time that I went to practice.
I'd like to now move on to your mock trial experience. For the jury who don't know, what is mock trial?
Mock trial is essentially a simulated courtroom where two teams compete against each other, whether prosecution or defense, and each team, every member of that team has a specific role, and then we compete against each other to win points to win that round of the tournament.
What were Ms. Becker's roles on this team?
Typically, Avery was an attorney. She actually received numerous awards for it.
What was it like having Ms. Becker as your teammate?
Honestly, it was really difficult. She came to practice late and unprepared a lot of the time, which frustrated us.
What was Coach Brackman's response to this behavior?
Mr. Brackman never liked that she came.
Objection, Your Honor, hearsay.
Response from the plaintiff.
Your Honor, this is not hearsay under Rule 701 because it is rationally based on this witness's perception due to spending a large majority of time with both Mr. Brackman and Ms. Becker and watching them interact and listening to Mr. Brackman's conversations.
I believe the question was what was her response, and so I'll overrule that objection. She hadn't yet stated what was said, so I'll overrule that objection.
Ms. Cifuentes, could you explain what Coach Brackman's response to this behavior was?
Yes, Mr. Brackman was agitated with Avery. He didn't like that she came unprepared to practice or late.
I'd like to move a little forward in time to the practice after regionals.
Objection, Your Honor. Counsel is leading the witness.
Response from plaintiff?
Your Honor, I am just trying to explain what I am discussing next before introducing my next question.
It's sending background information. I'll overrule the objection. Proceed.
Ms. Fuentes, you were on the mock trial team the same year as Ms. Becker, correct?
Yes, I was.
And Ms. Fuentes, were you at the practice after regionals?
Objection, Your Honor. Assumes the fact not in evidence that there was indeed a practice after regionals.
Now, counsel could ask one other question to lay a proper foundation. I'll sustain that objection.
Ms. Fuentes, did you have any practices prior to any competitions?
Yes, and we had many after competitions as well.
And did you have a practice after regionals?
Yes, we did.
Could you explain what happened during that practice?
Yes, Mr. Brackman and Avery got into another argument, which led to her demotion, I believe.
And what happened after she was demoted?
Well, one of our teammates, Mr. Perkins, stepped down from the mock trial team, which led Avery to gain her place.
Ms. Fuentes, could you explain what happened after she was back on the team?
I'm sorry, could you rephrase the question?
Yes. Ms. Fuentes, could you please explain what happened after Ms. Becker was put back on the team after regionals?
Oh, she and Coach Brackman got into an argument concerning the awards that she won.
Objection, Your Honor. Hearsay.
Response from the plaintiff?
Your Honor, once again, this is not hearsay under Rule 701 due to Ms. Fuentes being there during the situation and is rationally based on her perception.
I'll overrule the objection. I believe the witness was just stating what she observed and wasn't stating what specifically was said. So proceed. The witness may answer the question.
Ms. Fuentes, could you explain what happened after regionals?
Brackman and Avery got into an argument concerning the award she won at regionals, and it kind of blew up. She ended up grabbing a Sharpie and leaving the classroom.
Did you see Ms. Becker leave the room that day?
Yes, I saw her grab a Sharpie and leave the room.
And Ms. Fuentes, what was done with that Sharpie?
Objection, Your Honor. Hearsay. The witness did not see this event take place after Ms. Becker left the room.
Response from the plaintiff?
The witness did see the outcome of the result of what was done outside of the classroom and had Mr. Brackman, when returned, discuss it with her.
I'll sustain that objection. I think there needs to be a little more foundation as to what the witness was in a position to observe.
And Ms. Fuentes, could you explain what happened? Did Ms. Becker ever return to practice after leaving that night?
Did the witness hear the question?
I'm sorry, she did not return to practice.
And Ms. Fuentes, were you ever able to talk to Ms. Becker after?
Yes, I had multiple text conversations with her, and we spoke on March 5th, I believe.
You said you had multiple text conversations. Do you recall what was said in those messages?
Yes, I do.
Do you recall when you received those messages?
Yes, it was shortly after she was kicked completely off the team, but before Coach Brackman was murdered.
Would you recognize a copy of those texts if I showed you them here today?
Yes, I would.
Your Honor, permission to screen share Exhibit 14.
Granted.
Ms. Galganos, would you be able to screen share Exhibit 14 for us? Thank you. Could you tell the jury what is on the screen right now?
Yes, this is a text message chain between myself and Avery.
Is it a fair and accurate copy of the text you sent, please?
Yes, it is.
Your Honor, at this time, the prosecution moves to admit Exhibit 14 into evidence.
Any objection from the defense?
Yes, Your Honor, I object on the basis of hearsay of the statements made by Ms. Cifuentes and a lack of foundation.
What is the lack of foundation?
The witness did not testify about, I don't think the witness testified enough as to when these text messages were sent, what the situation was. And I don't think that there's been sufficient foundation laid.
Response from the plaintiff?
Your Honor, would you like me to respond to lack of foundation first or hearsay?
We'll take them one at a time. The first objection was foundation. The second was hearsay.
Your Honor, this is not lack of foundation due to I have had the witness explain when she had received these messages and what they are.
Okay, as to the hearsay, what's your response to that?
This is not hearsay under Rule 801D2 due to it being a statement of the opposing, a statement of the opposing, my apology, a statement of the party opponent.
I've been tongue-tied on that before as well. I'm going to override the, overrule the foundation objection and the hearsay objection. Exhibit 14 is admitted.
Ms. Cifuentes, could you explain what this conversation was started about?
Yes, Avery wanted me to talk to Coach Brackman about her potentially being able to come back on the mock trial team.
Was Ms. Becker ever able to return to the team?
No, I talked to Coach Brackman, but he wouldn't let her back on.
And what was your initial response to receiving these texts?
Well, I wanted to help Avery. She's one of my friends. So I talked to Coach Brackman, but there was nothing I could do for her.
Could you please read out loud the text, starting from the text that begins with if?
Sorry, which text?
The text that begins with if Brackman. Otherwise, the text.
Well, if he's still upset about his car, then he's going to be real upset when he sees what I do to his house.
Was there any part of these text messages that particularly concerned you, Ms. Cifuentes?
Yes, the portion where she talks about potentially breaking in and trashing Mr. Brackman's house was concerning.
No further questions, Your Honor.
Thank you. Mr. Nolan, will you judge at the end of each witness or do you need time now?
I think at the end of each witness.
Okay, thank you. The defense, any cross-examination?
Yes, Your Honor.
Please proceed.
Good morning, Ms. Cifuentes. I have a few questions for you as well. You and Avery Becker were basically best friends, right? I'm sorry, I couldn't hear you. You and Avery Becker were basically best friends, right?
Yes, I believe so.
But let's talk about how you viewed your best friend. First, you wondered why Mr. Brackman put up with Ms. Becker on the mock trial team, right?
That's correct.
You didn't like the way Ms. Becker treated the team or Mr. Brackman.
Again,
Your Honor, objection, speculation.
Defense, any response?
Your Honor, I was simply asking the witness her thoughts and her opinions on Ms. Becker and such. This is not speculation.
I'll overrule the objection that witness can answer.
Let me ask that question again, Ms. Fuentes. You didn't like the way Ms. Becker treated the team or Ms. Fuentes, or excuse me, or Mr. Brackman, right?
That's correct. I didn't like that.
You thought she always played the victim.
She did.
You thought she won mock trial awards without any real talent.
That's correct. She often made things up on the fly.
That wasn't my question about what she did during mock trial tournaments. You thought she won mock trial awards without any real talent, right?
Yes.
You agreed with Mr. Brackman demoting your best friend to the B team, correct?
Yes, I do.
So you didn't even want your best friend on the same mock trial team as you?
Well, I agreed with the demotion based on what her actions were, not based on whether she was my friend or not.
You, in fact, wanted Mr. Brackman to press criminal charges against Miss Becker for what happened to his car, right?
Well, he never did.
I didn't ask about whether he did or not. You wanted him to press criminal charges against Miss Becker for that, right?
I believe so.
But he was too caring and loving, right? You have even accused your best friend of this very crime that she's on trial for today, right? I'm sorry, Mr. Fuentes, once again, I couldn't hear you.
I can't hear her either.
Your
Right,
Honor,
I
we
can-
ask that the timer be stopped.
I'm keeping track of that, but Miss Cifuentes, we couldn't hear you. I could see your lips were moving, but we couldn't hear your answer. Can you answer again?
Could you repeat the question, please? I didn't hear it.
Yes. You've accused your best friend of this very crime that she's on trial for today, right?
Yes, I believe she committed this crime.
Further, Mr. Fuentes, while this case was being investigated, you did not hesitate to speak with the prosecution investigator, right?
Yes.
But however, you had no interest in speaking with a defense investigator representing your best friend, right?
Yes, I believe she was going to twist my words.
Let's talk about those text messages you testified about on direct. You don't have that cell phone anymore, do you?
No, I do not. It wasn't holding a charge, so we ended up trading it in. I don't know where it is now.
And the police didn't ask you to keep that cell phone, did they?
No, they did not.
Despite your belief of you being skilled at mock trial, your testimony under oath today is that you got rid of evidence relevant to a murder trial, right?
I'm sorry. I sent them screenshots as they told me to do so.
But your cell phone indeed contained those text messages,
Yes, it did.
and you got rid of that cell phone.
Yes, I didn't. Yes, I got rid of it.
That means we're not able to have a download of the cell phone's contents, are we, Mr. Fuentes?
No, but the police told me to send in screenshots of the text messages, which I did. I offered to bring my phone back in, but they said it wasn't necessary.
Everyone in the courtroom knows your testimony that those texts indeed came from Miss Becker, but for the record, you never saw her type or send those text messages, did you?
No, I did not.
Finally, you said on direct that Miss Becker told you she was going to do something to Mr. Brackman's house. In fact, you received texts and you believed them, right?
Yes, I did.
But you never at any point in time warned Mr. Brackman about that, did you?
Oh, I didn't think she was actually going to go through with it.
Is that your testimony today?
I'm sorry. The text messages stated that she was going to do that. I wasn't sure if she was going to or not.
But you never at any point in time warned Mr. Brackman about that.
No, I did not.
And you never called the police or alerted any authorities.
No, I did not.
In fact, Mr. Fuentes, it was not until 3 months after Mr. Brackman's death, when the police called you, that you decided to inform them about these text messages. Isn't that right?
Yes, that is also correct.
Thank you. No further questions, Your Honor.
Thank you. For scoring purposes, we'll add 20 seconds to that because of the audio difficulty. Any redirect by plaintiff?
No redirect, Your Honor.
Thank you. The witness may step down from the imaginary witness.
Okay, I'm ready for the next witness, Your Honor.
Thank you. Plaintiff, call their next witness, please.
Your Honor, at this time, the prosecution would like to call to the stand Kyle Kuzak.
Thank you. And Ms. Chavez, I had a little trouble hearing you. Maybe if you could be a little closer to your speaker.
Yeah, I can do that. Is this better if I raise my
It is.
Yes.
Okay.
Okay. And then, I'm sorry, the name of the witness?
Kyle Kuzak.
Oh, I want to say Kyle Kuzma, but Kyle Kuzmak. Thank you. Please proceed.
Hello, Kyle Kuzak. Can you please introduce yourself to the jury?
My name is Kyle Kuzak.
And what do you do for a living?
Well, I'm a crime scene reconstruction investigator for the Denver Police Department.
How long have you been working with the Denver Police Department?
3 years.
How many years of experience do you have?
I have 19 years of experience investigating complex crime scenes. This includes home invasions, burglaries, and other property crimes.
Do you have any certifications as a crime scene reconstruction investigator?
Indeed, I do. I am certified by the state of Colorado.
Your Honor, at this time, we tender this witness as an expert in crime scene reconstruction.
Response from the plaintiff or from the, excuse me, from the defendant?
We'll allow that, Your Honor.
I'm sorry, I didn't hear the first part of what you said.
We will allow that, Your Honor.
Okay, thank you. So admitted. Please proceed.
Mr. Kuzak, what were you assigned to do in this case?
Well, I was assigned to analyze, as my job is, and organize all of the evidence present at the scene of the crime, and then use that along with other evidence found to figure out a sequence of events that points towards what happened on the day of March 6, 2020.
Was there enough evidence to conclude your research?
Indeed, there was, yes.
And what method did you use for your analysis?
Well, I use the common CSI method, the Bevel-Gardner 7-step methodology.
Did you use the finding of other investigators to conclude your research?
I always do, yes.
And what did the police find at the scene of the crime?
Well, the police found the dead body of Mackenzie Brackman and a bloody knife next to him.
Where was the body found?
The body was found just inside the front door of the Brackman residence.
Would you recognize photos of the dead body and the knife if I were to show you them?
I believe I would, yes.
Your Honor, permission to screen share exhibits 1 and 5.
Yes, granted.
Ms. Galgano, could you please screen share? Mr. Kuzak, what are these?
Well, exhibit 1 on the left there is a picture of the victim, Mr. Brackman, dead, face down on the floor, while exhibit 5 on the right is a picture of the bloody knife that was found next to him.
Do these pictures accurately reflect the scene as it was found by the police?
They do, yes.
Your Honor, at this time, the prosecution moves to admit exhibits 1 and 5.
Defense?
We have no objection, Your Honor.
Exhibits 1 and 5 are admitted. Thank you.
Thank you, Ms. Galgano. You may stop screen sharing. Mr. Kuzak, what else was found at the scene of the crime?
Well, there were also multiple pieces of evidence that suggested signs of a struggle or a scuffle, if you will. These included scuff marks on the floor, blood spatter, a broken plate, and an overturned chair.
Would you be able to recognize photos of such things you had just mentioned if I were to show you to them?
Yes, I would.
Your Honor, permission to screen share exhibits 9 and 18.
Granted.
Ms. Galgano, can you please screen share exhibits 9 and 18? Mr. Kuzak, what are these photos?
Well, exhibit 9 on the left shows the broken plate I was talking about, and exhibit 18 shows the scuff marks by the back door I was also talking about.
Do these pictures accurately reflect the scene as it was found by the police?
They do, yes.
Your Honor, at this time, the prosecution moves to admit exhibits 9 and 18.
Response from the defense?
No objection, Your Honor.
Exhibits 9 and 8. I'm sorry, exhibits 9 and 18 are admitted.
Mr. Kuzak, what do these photos indicate?
Well, these photos clearly indicate that the victim and the perpetrator engaged in a struggle.
Thank you, Ms. Galgano. You may stop screen sharing. What else was found at the scene of the crime?
The Brackman residence had a motion-activated security system. This security system is called Ring.
As you had mentioned, these Ring videos, were you able to review them?
Yes, the Brackman residency had 3 of these security cameras, and I was able to capture and obtain video sequences from all of them.
Are you familiar with Exhibit 12?
I believe I am, yes.
Has Exhibit 12 been altered in any way from when they were originally obtained?
To my knowledge, it has not.
Your Honor, permission to play Exhibit 12.
Granted.
Ms. Galgano, can you please screen share Exhibit 12?
Your Honor, objection. If the
I'm sorry, stop the video. What's the defense objection?
I know it is a little bit late, Your Honor, but I would object. I would ask that this be actually admitted into evidence before the video is played before the jury. And since it has already been played, I would ask that the video be stricken from the record until it is admitted into evidence.
Plaintiff's response to that?
Your Honor, may I please move to admit Exhibit 12?
Okay. I think there needs to be a little more foundation. Could the plaintiff add a little foundation of what this video represents and who filmed it? Lay a little more foundation, please.
Mr. Kuzak, what is Exhibit 12?
Well, Exhibit 12 is a video sequence of a masked intruder entering through the back door of the Brackman residence, also the victim's house.
What did you conclude using this video?
Objection, Your Honor. Trying to testify about an exhibit not yet in evidence and draw conclusions from it.
I'm going to pretend I've just sequestered the jury so I can view the video. So I'll overrule that objection at this point, and I've sequestered the jury and as if they're out of the courtroom right now. So I'll allow the exhibit, I believe, number 12 to be played at this time.
Your Honor, the prosecution moves to admit Exhibit 12.
I'd like to back up one step and replay it because it was there was an objection while it was being played. So I'd ask if we could play Exhibit 12 again.
Ms. Galgano, can you please screen share Exhibit 12?
Okay, thank you. Does the defense have any objection to the admission of Exhibit 12?
No objection, Your Honor.
Okay, thank you. Exhibit 12 will be admitted.
Your Honor, at this time, the prosecution moves to admit Exhibit 12.
Okay, Exhibit 12 is admitted, so please proceed.
Thank you, Ms. Galgano. You may stop screen sharing. Mr. Kuzak, can the perpetrator be identified in the video?
The perpetrator cannot be identified because they are wearing a hoodie, a mask, gloves, and other full body coverings. It can be concluded from this video and the other ones obtained that the perpetrator seen in the videos is the same height and build as the defendant.
Thank you. Now I would like to move on to what happened inside the house. Mr. Kuzak, what happened once the suspect entered the home?
Well, the victim was informed by the Ring security system of the perpetrator's presence and entrance, and he retrieved a knife from his kitchen knife block to protect himself.
What happened next?
Well, as earlier exhibits have shown, the perpetrator and the victim have engaged into a struggle. And then the broken plate in Exhibit 9 shows that they continued this struggle away from the back door, moving towards the kitchen of the residence.
And then what happened?
Well, then the evidence suggests that the victim and the perpetrator continued this struggle, but began moving from the kitchen towards the front door of the residence.
What happened as a result?
Well, as a result, you can see in Exhibits 1 and 5 that the victim was stabbed and then left dead right before his front door, and the perpetrator flees.
Do you know the cause of death?
I do, yes. Coach Brackman died from a stab wound that occurred during the struggle.
All right, and what final overall conclusion did you make about the day of March 6, 2020?
My final overall conclusion of this tragic event is that it is the outcome of a burglary gone wrong.
Thank you, Your Honor. No further questions.
Does the defense have any cross-examination?
Yes, Your Honor.
Please proceed.
Now, I also have a couple questions for you today, Mr. Cusack. First, although we don't dispute your qualifications to testify today, we have heard that you are not a certified police officer, right?
Yes, I am not a certified police officer.
You've not gone through law enforcement training or certification, right?
No, I have not, but I have 19 years of experience in my job.
But you still have not received that certification, right?
No.
We have also heard that you went to the crime scene only after it had been processed and the body removed, right?
That is correct.
Now, I want to go over some of the evidence that police don't have in this case that is sometimes discovered in a criminal investigation. First, we do not have identification for the intruder because he or she was wearing heavy clothing and a mask, right?
Yes, you saw that in the videos.
So we don't have any identification, right?
No.
And nothing in this investigation shows anything about whether that mask or heavy clothing was retrieved from my client, right?
No, there is nothing.
And third, we do not have any DNA evidence from the scene, right?
We do not have DNA evidence, but there's a clear explanation for this. DNA evidence is
Mr. Cusack, since you've answered my question, I'm going to go on. Fourth, we do not have any fingerprints at the scene, correct?
No fingerprints or DNA were found.
Fifth, of course, we have no eyewitnesses because the victim has died, right?
Yes, clearly.
Adding all of these up, there is no physical evidence at the scene of the crime connecting this crime to my client at all, is there?
No, nothing besides the height and build seen in the videos.
Now, let's discuss some of the theories that you made in your investigation. First, you theorized that there was a struggle between the intruder and Mr. Brackman based solely on some scuff marks by the floor and a broken plate, right?
Also an overturned chair and other pieces of evidence. That is correct.
What other pieces of evidence are those?
The overturned chair.
But that's all, right? There's no other evidence of a scuffle, right?
Yes.
And as we just discussed, you theorized that Mr. Brackman struggled with the intruder. However, in the coroner's report for this case, which I believe you reviewed in your investigation, it shows that there is only one wound to Mr. Brackman, that stab wound. So there are no defensive wounds on Mr. Brackman's body, right?
Yes.
You have also previously stated that the intruder and Mr. Brackman were close together, probably in a bear hug sort of position, when the intruder reached over and stabbed Mr. Brackman in the back. Could you just demonstrate that motion real quickly for the jury?
Yes, I believe I can. I believe it would have looked something like this.
All right. Now, you also theorized that Mr. Brackman was alerted, to the intruder's presence based solely on the presence of a ring device, right?
Yes, the security system would have sent a notification to Mr. Brackman's phone, and he would have clearly been, would have known of the perpetrator's presence.
Mr. Cusack, I believe in your testimony, you do not say anything about whether you investigated if Mr. Brackman had received those alerts, right?
No, I didn't.
So you cannot say for certain whether or not he received the alerts, right?
Not for certain, no.
Now, you also theorize that Mr. Brackman was stabbed near the kitchen, proceeded to the front door where he pulled the knife out and dropped it there, right?
Yes.
Part of your support for this theory is that there were blood droplets leading from the kitchen to the front door, where there was a lot of blood on the floor, on the walls, on the ceiling, on Mr. Brackman, certainly, and on the knife, right?
Indeed, yes.
Please look at exhibits 4 and 5, with which my co-counsel will screen share on the screen in front of you. Now, exhibit 4 is a picture of Mr. Brackman laying in a pool of blood, and then exhibit 5 is a picture of a very bloody knife. You use these in your investigation, including trusting their accuracy, right?
I did use these, yes.
As we just established, your theory is that Mr. Brackman pulled the knife out of his own back, right?
That is correct, yes.
But despite all of the blood everywhere, can you show me in exhibit 5 where you see any blood on Mr. Brackman's hands or wrists?
No, I cannot. I do not see him.
So there's no blood on Mr. Brackman's hands or wrists, right?
No, you can clearly see that in the image.
And further, in exhibit 5, do you see any bloody fingerprints or handprints on that knife?
No, you do not.
And remembering that Mr. Brackman had just been fatally stabbed, could you demonstrate to the jury how he would have been able to pull that large of a knife out of his own back without cutting himself and certainly without getting any blood on his hands or wrists?
I cannot demonstrate it, but it probably would have looked something with his hand reaching behind his back, pulling the knife out of his back.
Would he have been able to do that without getting any blood on his hands or wrists?
It is possible, though unlikely.
Finally, you gave an 8-page statement for this case, right, Mr. Cusack?
Yes, I did.
The statement contains everything you know of that could be relevant to the facts of this case, right?
It does.
In those 8 pages and 176 lines of testimony, nowhere do you give the opinion that my client, Avery Becker, committed this crime, do you?
No.
And further, in your 8-page statement, nowhere do you even mention Miss Becker's name, right?
That is correct.
Thank you. I have no further questions, Your Honor.
Is there any redirect from the plaintiff?
No, Your Honor.
Okay. The witness may be excused.
Okay, I'm ready for the next witness.
The plaintiff or prosecution call their next witness, please.
The prosecution calls Jordan Markowitz to the stand. Would you please introduce yourself to the jury?
My name is Jordan Markowitz.
What do you do for a living?
I've been a cop for 13 years and a detective for 7.
Were you involved in the investigation into the death of Mackenzie Brackman?
Yes, I was the lead investigator.
We will come back and talk about your investigation later, but first, let's talk about your background. You mentioned you're a detective. Where do you work?
I work at the Denver Police Department as a homicide detective.
Do you have any specialized training?
Yes, I have specialized training in cell phones.
Could you explain exactly what that training is?
I have been certified by the American Academy of Law Enforcement in cell phone technology and forensic data recovery. I took a 3-day training course and passed the certification test.
Do you use your training in cell phone technology as a detective?
Yes, I use my training every day. I've literally analyzed the contents of hundreds of cell phones. I've also analyzed and interpreted cell phone tower data in over 50 cases.
At this time, the prosecution moves to tender Detective Markowitz as an expert in cell phone technology and cell tower data analysis.
Any response from the defendants?
No objection, Your Honor.
This witness will be admitted as an expert in cell phone technology and cell phone data. I didn't catch the last part of but the witness will be so admitted.
Now, you mentioned being an expert in cell phone technology and cell phone tower analysis. How did your expertise help in this case?
I used my expertise to track Avery Becker's phone with the cell phone towers.
Did you come to any conclusions based off of this information?
Yes, I came to the conclusion that Miss Becker was on her way to Mr. Brackman's home.
Now, what led you to reach this conclusion?
I reached this conclusion because Miss Becker's phone was connecting to several cell phone towers moving in the direction of Mr. Brackman's home.
Based off of your further knowledge as an expert in cell phone data, could you explain to the court what CDRs are?
A CDR is a call detail record, and it basically means even when your phone's not in use, it is always trying to reach out and connect to a cell phone tower.
Did these CDRs lead to any more conclusions about the case?
Yes, it did. Oh, sorry, excuse me. Yes, it led me to the conclusion that the defendant was at Mr. Brackman's home the day of the murder.
Did you produce a map or graphic of your findings?
Yes, it did. Yes, I did.
Do you recognize an exact copy of this map if it was shown to you?
Yes.
Your Honor, permission to screen share Exhibit 15.
Granted.
Ms. Galgiano, could you please screen share Exhibit 15? What is this picture showing, Detective?
This picture shows the route Avery Becker was taking the day of the murder. This image shows she was headed in the direction of Mr. Mackenzie Brackman's home. And I believe Ms. Becker was on her way to Mr. Brackman's home in order to vandalize it.
Is this a fair and accurate picture of the cell phone tower map?
Yes.
Does it appear to have been changed or altered since you last saw it?
No.
At this time, the prosecution moves to admit Exhibit 15 as evidence.
What's the defense position?
No objection, Your Honor.
Exhibit 15 will be admitted.
Your Honor, under Competition Rule 7.4, we would like to ask that the witness can mark this evidence electronically.
No problem. That's granted.
Could you mark this map to show your route to the jury, Ms. Markowitz?
Yes.
When and where was the first connection to a cell tower?
The first connection was here at 1227-3 at 12:47 in the afternoon.
And the next connection?
The next connection was here at tower 1191-1 at 12:55 in the afternoon.
And the final time?
The final connection was here at tower 1197-1 at 1:05, 1:06, and 1:07 in the afternoon.
Just to clarify, were these text messages or phone calls?
These are both text messages and phone calls, all made to the defendant's phone from Taylor Perkins.
Could you summarize the route that the defendant took throughout this map?
Sure. If you can see here, this is where Ms. Becker's phone is, and here is where Mr. Brackman's house is. House. And this is the route that I believe that Ms. Becker took. I believe she traveled along Rock Creek Parkway.
Objection, Your Honor. Under the best evidence rule, this is an exhibit. I believe this witness is about to mark this exhibit as to show, yes, there it is, as to show the route. But we do have an exhibit of this exact same map with a line down the middle for the route. We request that they admit that exhibit instead of continuing to mark on this one.
A plaintiff response, a prosecution response.
Your Honor, this is perfectly admissible under best evidence because it is a record of a public office. And while both maps do display information related to the cell towers, they are both overall a summary of information that is too difficult to display to a jury under our time constraints. So I would argue that this piece of evidence is admissible as well.
I'll overrule the objection and allow the witness to make the mark. The defense could cross-examination with their own exhibit as to any discrepancy. So please proceed.
I'll simply repeat my question. Ms. Markowitz, could you summarize the route that you believe the defendant took throughout this map?
As you can see here, I drew on the map, and I believe that the defendant was traveling along Rock Creek Parkway and down to Mr. Brackman's home.
Finally, based off of this evidence, do you have an opinion about the defendant at these times?
Yes.
What is that opinion exactly?
My opinion was the defendant was on her way to was at the scene of the crime at the time of the crime, the day of the crime.
Your Honor, permission to preserve the annotation that Ms. Markowitz made throughout this direct examination.
Granted.
No further questions.
Cross-examination from the defense, please.
Yes, Your Honor. Detective Markowitz, let's talk about your initial consideration of this case. Figuring out motive is always important in criminal investigations, isn't it?
Yes.
And when you first considered the evidence at the scene, you thought this could be the work of a disgruntled ex-client of Mr. Brackman's, correct?
Yes.
And you thought that because Mr. Brackman was a defense attorney who represented defendants, didn't he?
Yes.
And if he represented someone who lost and thus became a disgruntled ex-client, that could be motive for murder, couldn't it?
Yes.
Ultimately, however, you did conclude it was very unlikely that it was an ex-client who killed Mr. Brackman?
Yes, I did.
But by that same vein, you also thought that it was highly unlikely that Mr. Brackman's mock trial activity had anything to do with this murder case, didn't you?
Yes, I believe that really didn't have any. Yeah.
About the day of the crime, you believe that that Mr. Brackman, my apologies, armed himself, correct?
Yes, with a knife.
Then struggled with the intruder.
Yes.
And the intruder got the knife away from Mr. Brackman and killed him, correct?
Correct, that's what I believe.
However, in the coroner's report that you reviewed for your investigation, it doesn't show any other injuries to Mr. Brackman other than the fatal stab wound, correct?
No, but there's evidence around the house that suggested a scuffle.
Let's talk about the issue of cell phone data. You focused on Avery Becker's cell phone for this case, didn't you?
Yes.
And you obviously were not able to confirm whether or not Avery Becker was in possession of her phone on March 6, 2020, because you weren't there.
No, I was not able to.
Your records did show that on March 6, 2020, Avery Becker's phone was receiving multiple unanswered texts and calls from Taylor Perkins' phone, correct?
Yes, that's correct.
And when Taylor Perkins spoke with the police, she did tell them that she was with Avery Becker the entire day of the murder, correct?
Yes, but I don't believe that.
When someone claims to be with a defendant during a crime, that's called an alibi, isn't it?
Yes, it is.
And you did not investigate this alibi, did you?
No.
Now let's talk about some more things that didn't happen in this case. You previously stated that you received some screenshots of text messages from Alex Cifuentes.
Yes.
But you did not actually see that phone itself, did you?
No, Ms. Cifuentes just forgot her phone, and it's an easy mistake. She must have just been nervous for the interview.
But you did not see the actual messages on that phone itself, did you?
No, I did not.
And without access to this phone, you also were not able to download any messages or cell phone data from it, were you?
No, I was not able to.
And this might be the only time in your 13 years of law enforcement that you have ever known of a teenager to be without their cell phone. Is it?
Yes, I thought it was a bit unusual, but again, it's nerve-wracking to come talk to the police.
Detective Markowitz, those are your exact words. I can turn you to your witness statement if you would like.
No, I do believe that it might have been the only time.
So you did not obtain Alex Cifuentes' phone, and you also didn't obtain my client's cell phone, did you?
No.
Next, and maybe most importantly, you did not do a detailed investigation of Blair Rollins, did you?
No, I did not.
You do know who Blair Rollins is, though, don't you?
Yes, I do.
And you did not do a detailed investigation, despite your colleague, Kyle Cusack, identifying Blair Rollins as a suspect in this case.
No, I did not, because evidence was pointing towards Avery Becker.
If you could please turn to Exhibit 16, which should be on page 74. This map shows the towers you believe Avery Becker's phone pinged off of on March 6, 2020, correct?
Yes, that's correct.
And you created this, didn't you?
Yes.
So then surely it fairly and accurately represents the information you obtained from my client's call detail records.
Yes.
Your Honor, the defense offers Exhibit 16 into evidence.
Any response from the prosecution?
No, Your Honor.
Exhibit 16 will be admitted.
Detective Markowitz, on this map, Blair Rollins and Avery Becker live in the same cell tower sector, don't they?
Yes, they do.
And that blue line down the middle is the path that you believe Avery Becker took to get to Mr. Brackman's house on March 6th, 2020, correct?
Yes, that's correct.
And on this map that you created, Blair Rollins could have taken a nearly identical route and hit the same cell tower sectors, couldn't they?
They could have, but other evidence was pointing that Ms. Becker was there.
Now let's turn to the videos in this case, specifically Exhibit 12, which I believe has been previously admitted. If my co-counsel could share that to the screen, please. In this video, when the intruder walks up to the door, can you see them look into the house before they enter?
Yes.
And you claimed to enter through this same way when you went to investigate the crime scene, correct?
Yes, that's correct.
And when you enter, you go directly into the kitchen, isn't that right?
Yes, that's correct.
Finally, the videos in this case show the intruder wearing a mask, a hoodie, and gloves, correct?
Yes, that's correct.
At no time have you ever mentioned law enforcement collecting a mask from my client, have you?
No, we have not.
At no time have you ever mentioned law enforcement collecting gloves from my client, have you?
No, we have not.
And at no time have you ever mentioned law enforcement collecting a hoodie from my client, have you?
No, we have not.
No more questions, Your Honor.
Any redirect from the prosecution?
Yes, a very brief one. Now, Ms. Markowitz, would any of the information that the defense has just presented, including an alternate route or having not collected any of the defendant's items of clothing, changed your expert conclusion on this case?
Objection, Your Honor. Leading question.
I'll overrule the objection.
No further questions.
Thank you. Any recross to that redirect?
Your Honor, under the rules of mock trial, recross is not permitted.
Thank you. Okay, the witness may step down.
Okay, I need to back up just one point. I need the name of the defense counsel on the second witness. Was that Carol Ann?
Your Honor, that was Clara Ann Wind.
Clara Ann Wind. Okay, I am ready for the next witness.
Anything further from the prosecution?
The prosecution rests, Your Honor.
The defendant prepared to call their first witness?
Yes, Your Honor.
Please proceed.
My name is Rachel Kidder, and the defense calls Professor Blake Van Owen, who is being played by Logan Holtzinger.
Okay. Okay, Ms. Van Owen, you're okay. Please proceed.
Good morning. Please introduce yourself to the jury.
My name is Blake Van Owen.
What do you do for a living?
I'm a private investigator and college professor.
Professor Van Owen, please tell the jury about your educational background.
I have a bachelor's degree from the University of Colorado Boulder, which I received in 2005. I also received a master's degree in criminal justice from Ashford University in 2014.
Please discuss your work history.
I began my career as a police officer with the City of Aurora, Colorado Police Department, right out of college. I was with Aurora for about a year. Since working with Aurora, I ultimately became a private investigator and college professor.
What do you teach?
I teach a course on police practices and social justice at CU Boulder.
We will be offering you as an expert witness in this case. Do you have any experience testifying as an expert?
Oh yes, I have testified as an expert in the federal courts of Colorado, Kansas, and Arizona, as well as I believe the state courts of Colorado, Nebraska, Wyoming, and New Mexico.
Each time you have been offered as an expert, has the court found you qualified to testify as an expert?
Yes.
In what areas of expertise have you been qualified to testify?
In the fields of crime scene reconstruction, general police investigation tactics, cell tower data analysis, as well as police practices, use of force, false arrest, forensic evidence techniques, and that's all.
In how many cases have you testified as an expert?
In over 100 cases.
Your Honor, the defense offers Professor Blake Van Owen as an expert witness in the fields of police practices and criminal investigations.
Response from the prosecution?
No objection to either of those.
The witness will be admitted as an expert in police practices and criminal investigations.
Professor Van Owen, what were you asked to do in this case?
I was asked to review the case reports of Detective Markowitz, as well as the police reports. I was also asked to review the exhibits prepared by the detective, and as well as conduct my own partial investigation in any areas I believed were neglected by the police in this case.
Let's first discuss your review of what the police did. What are your professional opinions concerning their work in this case?
In my professional opinion, the investigation was rushed. Important things were missed, and their decision to prosecute Miss Becker was wrong.
Do you have any examples of rushed police work?
Yes, I do. Cusack claimed that Brackman and the intruder struggled, which resulted in the stabbing. But in my opinion, the evidence is too weak for this conclusion. For example, the prosecution uses scuff marks on the floor, but we don't really have any idea to tell when those were made or how they were made.
Do you have any more issues with Cusack's theory?
Yes, I disagree with Cusack's theory that the victim had surprised the intruder by carrying a knife.
Professor Van Owen, in your professional opinion, how do you view the knife evidence?
The knife that Mr. Brackman supposedly grabbed and was stabbed with in Cusack's theory is a different knife than the others in the knife block. So this actually leads me to believe that this was an intentional attack with a knife that the intruder brought to the crime scene.
We will return to your conclusion. Is there any other things that the police rushed?
Yes, based off of the knife's downward stabbing position, Cusack believed that the intruder was in front of Mr. Brackman. However, for this theory to even work, the intruder would have to be taller than Mr. Brackman, but it's made clear from the ring security videos that the intruder just wasn't taller.
If Mr. Brackman was not stabbed during a struggle, what was more likely to have happened?
It is more likely for the intruder to have been standing behind the victim based off of the angle and depth of the wound. Furthermore, the victim, Mr. Brackman, was likely sitting. Additionally, because how the knife was stabbed today in court, Cusack testified that the knife was stabbed in a downwards position, kind of like this, which supports my theory and contradicts actually what I read in his police reports today.
Did the police make any other assumptions once focusing on Avery Becker?
No, well, actually, yes. Not around Avery Becker, but they did assume that the ring security videos alerted Mr. Brackman to the intruder, but we have no idea to tell if those notifications were on or off.
We've established that the police made unfounded assumptions. Now let's talk about some of the conclusions that they reached. Do you have any criticisms of those conclusions?
Actually, yes. The police concluded that Avery Becker was near Mr. Brackman's house because her cell phone pinged off a tower that was not very far from where Mr. Brackman lived. This is an incredibly simple statement in a field that's just so complex.
What do you mean?
What I mean is that cell phones are able to connect to multiple towers at once, and in addition, they often don't connect to the nearest tower. It's
Objection,
more
Your
likely.
Honor. The witness is testifying to something that's outside of their field of expertise.
Your Honor,
Response from the plaintiff or prosecution?
in
Or
criminal
defense?
investigations now,
I'm sorry. Response from the defense.
yes, Your Honor, in criminal investigations, as Detective Markowitz testified to, cell phones are a daily part of these. So cell phone analysis is part of criminal investigations nowadays.
I'll overrule that objection. I think the question's within the scope of this witness's expertise. Please, please respond.
So why is that too simple a conclusion?
It's too simple of a conclusion because cell phones are able to connect to multiple towers at once, and in addition, they often don't connect to the nearest tower. It's not unusual for a phone to generate 5 or 6 calls from the same location and link up to 5 or 6 different towers for those calls.
Why is that?
Well, additionally, I also believe that since cell phones are like this, GPS information is kind of how the prosecution is comparing this in the sense of the accuracy of GPS information, excuse me. But I believe that's not the same kind of accuracy we can get with cell phone towers.
Is there any evidence that contradicts the police's theory of Avery Becker being at the Brackman home?
Actually, yes. I believe that the stronger evidence in this case is that she was never at Mr. Brackman's house.
What is that evidence?
The evidence is that she was with her friend Taylor Perkins searching for her phone because she actually lost it the day before the murder.
Can you tell the jury the specifics of this evidence?
Yes, there are records of incredibly short calls and multiple unanswered texts indicating that they were indeed looking and calling for her deactivated device.
So do you have a theory as to what happened to Ms. Becker's phone?
Yes, personally, I believed that it was stolen.
Please tell the jury the factual basis for that theory.
I believe this was stolen by Blair Rollins and Alex Cifuentes at the Fry Shack one evening.
Do you have any other criticisms of Detective Markowitz's cell tower analysis?
Yes, I disagree with the fact that, again, I don't think it was very reliable information to find the location of Miss Becker.
So what conclusion did that lead you to?
Miss Becker was never at Mr. Brackman's house, and she never even had her phone.
We've heard from some of the prosecution's witnesses about some text messages. What is your professional opinion on this evidence?
In my professional opinion, these text messages are not authenticated properly. The police should have gotten access to the actual phone.
We've established that the police focused solely on Ms. Becker. After the conclusion of your own investigation, do you believe they should have looked into anyone else?
Yes, I do believe they should have.
Who else should the police have investigated?
Blair Rollins, who was another student at Colorado High School.
Why?
Blair Rollins had Mr. Brackman represent his father, Jonathan Rollins, in a criminal case. At the sentencing hearing, when Mr. Rollins was sent to prison for life, he yelled he was going to get revenge. Blair Rollins was present in the courtroom.
Sorry, could you repeat that, please?
Objection, Your Honor. Lack of foundation, specifically as to how this witness knows about this court proceeding.
Response from the defendant.
Your Honor, this witness has previously testified to conducting her own investigation. This would be part of that investigation, is looking into Blair Rollins and that specific court proceeding.
I'll sustain that objection. I think you could lay a little more foundation before the witness can answer that question.
Did you investigate Jonathan Rollins' court hearing?
Yes, I did.
And did Jonathan Rollins say anything after that court hearing?
Yes, he said he was going to get revenge.
Would you recognize an audio recording of that if you heard it?
Yes, I would.
Please turn to what has been marked as Exhibit 22, which should be on page 89. Do you recognize this exhibit?
Yes, I do.
What is it?
This is an audio recording from Jonathan Rollins' court proceeding.
How do you know?
I know because I obtained this record previously and I've listened to it before in my investigation.
Is Exhibit 22 a fair and accurate depiction of the audio recording you obtained over the course of your investigation?
Yes, it is.
Your Honor, the defense offers Exhibit 22 into evidence.
Response from the prosecution.
No objection, Your Honor.
Well, I haven't heard the exhibit, but since there's no objection, I'll admit the exhibit.
Are there any other reasons you're aware of as...
Sorry, please state that again. There was some
Yeah, my apologies, Your
background
Honor.
interference.
Are there any other reasons you are aware of as to why the police should have investigated Blair Rollins?
Yes, first of all, he had a much stronger motive because of his father's criminal conviction. Secondly, Blair Rollins and Avery Becker have the same build and body shape.
Where is Blair Rollins now?
No one knows. Blair Rollins has essentially disappeared.
Objection,
Finally-
Your Honor, lack of foundation.
I'll sustain that objection. There needs to be more foundation before that witness can answer that question.
Finally, Professor Van Owen, did you form a conclusion as to who killed Mackenzie Brackman?
Yes, in my professional opinion, the most likely suspect as of now is Blair Rollins. It most certainly was not Avery Becker. She had an absolute alibi. She was with Taylor Perkins at the time of the crime.
Thank you, Professor. No more questions, Your Honor.
Cross-examination.
Yes, Your Honor. Good morning, Miss Van Owen. I'm going to ask you a few questions. First, let's start with your background. You only testify for the defense, isn't that right?
Yes, that's the nature of my job.
Now, you're being paid between $6,000 and $10,000 for your testimony, correct?
Yes, that's normally how I charge.
And you were a cop for the Aurora Police Department?
Yeah, I was.
You injured a woman of color during her
Objection,
arrest.
Your Honor. Under Rule 403, this is unfairly prejudicial.
Response from the defense. Or
Now,
the prosecution, excuse me.
this goes to cast doubt on Miss Van Owen's skill as an expert on police procedure and does not go to move towards the testimony's admissibility whatsoever.
Your Honor, Ms. Van Owen's previous experience with the police department has nothing to do with her expertise and the two areas we offered her in. And we believe that specifically opposing counsel is going to testify to something that would be extremely prejudicial and could potentially get his point across without saying that thing.
I'm going to overrule the objection. I hadn't even heard the whole question yet. So please ask the question again.
You injured a woman of color during her arrest, correct?
Yes, unfortunately, I was following one of the police procedures and that happened.
Yeah, she sued you, correct?
Yeah,
Yeah, and you did settle with her?
I did settle with her.
And you left the department following this incident?
I did. I did not believe police work was what I initially thought it was, especially after that incident.
And that's exactly why you consider yourself a check on the power of the police, correct?
Yes, actually.
Now, let's talk about the prosecution's investigation. You agree that evidence shows at least someone breaking into and entering Mackenzie Brackman's home,
Yes,
but you don't think there's evidence of a struggle.
I do not think there's evidence of a struggle.
You are aware of the scuff marks on the floor?
Yes,
Well, this, of course, doesn't definitively prove a struggle. It could indicate a struggle.
well, yes, normally, but I don't believe that was the case.
And you're also aware that the police found a broken plate on the ground near the kitchen
Yes, I'm aware.
and an overturned chair.
Yes,
You criticized the police for losing pictures at the crime scene.
yes, I did.
However, these pictures would not have mattered anyway, would they?
Well, I think they're significant. It's unfortunate for the police to lose any kind of evidence.
However, they would not have mattered in definitively proving exactly who, exactly who killed Mackenzie Brackman.
I mean, if they're evidence relating towards a struggle, I do think that they're very valid in figuring out who did it.
Finally, you're aware that Avery Becker was absent from school on the day of the murder.
Yes,
Let's look at your personal investigation of this case. You know that you could have obtained cell phone records of Taylor Perkins from the day of the murder.
I realize I should have, but I beg to argue that the police should have as well.
Now, you did not obtain these records, however,
No, I did not.
but you think it is possible that these records could have supported Avery Becker's alibi.
Yes.
But you did not collect this vital piece of information for the case.
Well, yes, but again, the police didn't either.
Now, the cell phone tower near Brackman's house placed at least Avery Becker's phone near the vicinity of the crime, correct?
Yes, I do agree.
No further questions.
Any redirect from the defense?
Yes, Your Honor. Professor Van Owen, does your experience with the Aurora Police Department affect your investigation or any of your work in this case in any way?
Absolutely not.
No further questions, Your Honor.
The witness may step down.
Okay, I'm ready for the next witness.
The defense call their next witness, please.
The defense calls Taylor Perkins.
Hey, Ms. Perkins, you're under oath. Please proceed.
Good morning. Please introduce yourself to the jury.
Good morning. My name is Taylor Perkins.
Tell the jury a little bit about yourself, Ms. Perkins.
I'm a freshman at CU Boulder, and last year I graduated from Colorado High School.
Do you know Ms. Becker?
Yes, I do.
And how do you know her?
Avery and I are best friends. We went to high school together, and before I graduated, we were both on Mr. Brackman's mock trial team.
Did you see Mr. Brackman and Ms. Becker interact?
Yes, mostly at mock trial practices.
In your perception, what was the relationship like between the two of them?
It was probably strained.
Would you please explain that?
Avery was the type of person who had natural talent, who didn't have to work hard to be good. She was the best attorney on the team, but also worked the least. I saw that really bothered Mr. Brackman. She would come to practice late, was unprepared, and that made Mr. Brackman really mad.
Do you have any examples of Mr. Brackman getting mad?
Yes. About a month before the regional tournament, Avery came to practice the least prepared she had ever been, but she still did amazing in her closing argument. Mr. Brackman got really mad and demoted her to the B team.
What happened on the mock trial team after that?
About a week before the regional tournament, I resigned from the team because I thought Mr. Brackman had been unfair to Avery and to the entire team.
Was there any other reason you stepped down?
Yes, mock trial was not that important to me anyway, and without Avery, it just wasn't fun anymore.
So did the mock trial team go to the regional tournament without you and without Miss Becker?
No, after I resigned, Mr. Brackman put Avery back on the A team, which I thought might happen. And the team is fortunate I stepped down because Avery won Best Attorney and Best Closing Argument awards at the regionals.
Did Miss Becker then go to the state tournament with the team?
No, Mr. Brackman kicked her off the team again after the regional tournament, but I wasn't there when it happened. Anyway, the state tournament was canceled because of the stupid virus.
When did you next see Miss Becker after she was kicked off the team again?
Well, a few days later, she came to my house and we hung out for a while. Then that night, we went to the Fry Shack to get some food.
Did anything happen at the Fry Shack?
We saw most of the mock trial team there. Everyone was super friendly towards Avery and really upset Mr. Brackman had kicked her off the team.
Did anything else happen while you two were there?
Yes. Avery got really upset at something Alex Cifuentes said and stormed off to the restroom.
How did you know she was upset?
Well, I could just tell. And she left her cell phone on the table.
Why was it unusual that she left her phone on the table?
Just like most of my friends, Avery was pretty attached to her cell phone, so it's a little surprising that she left it there.
Did you pick up Miss Becker's phone when you saw it on the table?
No, I thought she would, but she didn't. We left in such a hurry.
So when did you realize Miss Becker left without her phone?
The next morning, when she was supposed to pick me up for school, she didn't respond to any of my texts.
Did you see her that day?
Yes, she came by and picked me up.
And what day was that?
It was March 6th, 2020, the same day that Mr. Brackman died.
What happened once Miss Becker picked you up?
Well, I asked her why she wasn't responding to my texts. Just then, we both realized she was missing her phone.
Did you do anything when you both realized that the phone was missing?
Yes, we really needed to find her phone, so we decided to ditch school and retrace our steps from the previous day since we both had first period off.
Where exactly did you look?
Well, we went to the mall and checked each store we had gone into. When we couldn't find it in any of those places, I remembered her phone being on the table at the Fry Shack, so we went back and checked there.
Did you find it at the Fry Shack?
No.
Did you do anything else to try to find the phone?
Yes, while we were searching, I used my phone to try texting and calling Avery's phone several times.
On March 6, 2020, how long did you spend searching for Miss Becker's phone?
We burned the whole day looking for that darn phone.
What happened after Miss Becker picked you up and you skipped school and you went to the mall and you went to the Fry Shack and you made all those calls and texts searching for the phone?
While we were still at the Fry Shack, we bumped into a few of the mock trial team members, which was pretty crazy.
Why do you say that?
Well, they should have been at practice, but Mr. Brackman never showed up, and the team couldn't get a hold of him.
Ms. Perkins, from the moment Avery Becker picked you up early in the morning on March 6, 2020, until the moment everyone left the Fry Shack, did Avery Becker ever leave your presence?
No, never.
Did the two of you go to Mr. Brackman's house at any time?
No, never. We don't even know where he lives.
Did you see Mr. Brackman at any time on March 6, 2020?
Absolutely not.
Ms. Perkins, do you know someone named Blair Rollins?
Yes, Blair was a classmate at school.
Do you know of any connection Blair Rollins had with Mr. Brackman?
Well, everyone knew that Blair Rollins was hateful towards Mr. Brackman.
Why was Blair Rollins hateful towards Mr. Brackman?
Because Mr. Brackman lost a case that sent Blair Rollins' dad to prison for life.
Finally, did Blair Rollins have a reputation at Colorado High School?
Well, everyone at the school agreed that if there was one person who could kill somebody and not think twice about it, it was Blair Rollins.
Ms. Perkins, I have just a few more questions for you. You know that Avery Becker is on trial for murder in this case. Have you ever experienced anything of a violent nature in Miss Becker?
Oh my gosh, no.
Do you have any reason to believe that she committed a burglary or a murder on March 6, 2020, or ever for that matter?
Have you ever seen Avery Becker? She's not even capable of those things. Absolutely not.
Finally, on March 6, 2020, after Miss Becker picked you up early in the morning, was she ever out of your presence?
Not for 1 second.
Thank you. I have no further questions, Your Honor.
Is there any cross-examination by the prosecution?
Yes, Your Honor. All right. Ms. Perkins, you're a Colorado High School alumni, yes?
Yes, I am.
And you participated in the mock trial there?
Yes, I did.
Would the attorney move a little closer to her microphone, please?
Yeah, please. I could hear you, but yeah, it was a little faint. If
No problem. Are you friends with the defendant?
Yes, Avery and I are best friends.
You only joined mock trial because the defendant had joined first.
Sorry, you broke up. I think I got the gist of your question, but could you maybe repeat it?
That you had only joined mock trial because the defendant had joined?
Yes, she was the main reason that I joined mock trial.
You joined to spend more time with the defendant?
Did you say I like to spend more time with the defendant?
You joined to spend more time with the defendant?
I mean, I guess you could say that. She was the main reason that I joined.
On the day of the murder, you claim you were with the defendant?
You broke up again.
On the day of the murder, you claim you were with the defendant?
Yes, I was with her all day.
No one can verify that you were with her, correct?
Well, we saw the whole mock trial team there. Well, not the whole time. Sorry, excuse me. We saw most of the mock trial team there at the Fry Shack that day.
Can anyone verify that you were at the mall with the defendant that day?
Not somebody specific I can think of.
Objection, Your Honor. Beyond the witnesses, it calls for an expert opinion, Your Honor.
I'll overrule that objection. The witness may answer.
So no one in this courtroom can testify to this today?
No, nobody in the courtroom.
So as you had already stated, you were on mock trial. Mackenzie Backman was your coach?
Yes, he was.
Avery and the coach would get into little feuds often.
Yes, they did.
These little feuds would often bother Avery enough to play pranks on the coach?
She played a few pranks here and there, yes.
You thought that the defendant could be rash and had an inflated ego?
She could be rash, yes.
The defendant would get upset with the coach?
Yes, she would.
The coach would give Avery a hard time?
Sometimes, yes.
He would call Avery lazy and unprepared?
Yeah, he would sometimes call her that.
A month before regionals, Avery went to practice completely unprepared, right?
Yes, I testified to that in my direct already.
You thought that this had made the coach mad?
Yes, he got really mad.
And Avery was demoted to Team B, correct?
That is correct.
As a result, you stepped down so Avery could take your spot?
Again, correct.
So if you're willing to quit the team, would you be willing to lie for your best friend?
Objection, Your Honor. Improper question, lack of foundation.
A response from the defense.
Your Honor, I withdraw my question.
Okay.
Sorry. The defendant told you that Coach Backman said she didn't deserve the award she had gotten, correct?
Objection, Your Honor. Hearsay.
Sorry, could you repeat the question, please?
The defendant told you that Coach Backman said she didn't deserve the award she had gotten.
The objection is hearsay. What's the response to that?
Your Honor, I'm asking this question not to state a truth. I'm just going to the effect of the listener, which goes to motive under Rule 801D2. I'm not trying to prove the truth of the matter.
I'll overrule the objection. The witness may answer.
Could you repeat the question? Oh, sorry.
Oh, yeah. So the defendant had told you that coach had said she had not deserved the award she had gotten. Correct?
Yes, she did say that.
The comment from the coach made Avery mad, right?
The call room? Sorry?
The comment.
Oh, the comment. Yes, she was frustrated by that comment.
And the defendant also told you that she wrote worst attorney award on the hood of the Porsche of Mr. Brackman.
Objection, Your Honor, hearsay.
Response from the defense?
Your Honor, this also falls under Rule 801. I'm asking about a statement of the defendant.
I'll overrule the objection. It's a statement by a party opponent. Please answer.
So the defendant told you she had wrote worst attorney award on the hood of the Porsche of Mr. Brackman?
That's what she told me, but I wasn't there, so I can't testify to that.
After this, the coach decided to kick Avery off the team, right?
Yes, that is correct.
And Avery tried everything to get back on.
That I'm aware of.
But Coach Brackman still said no. Correct?
Yes, I mean, again, I wasn't there for these events, so I don't know how you expect me to testify to them.
Avery texted everyone on the team to try to get back on.
Objection, Your Honor. Your Honor, I withdraw my objection.
Thank you. Please ask the question again.
Avery texted everyone on the team to try to get back on.
I'm not sure.
All right. On the last effort, Avery showed up on a Thursday practice the day before Brackman was murdered, correct?
I don't know. I wasn't there, so I can't testify to that.
And she was told to leave. Okay. So from what you saw, the defendant always kept her phone on her, correct?
Yes, she was pretty attached to it.
It was like her third kidney.
I suppose so.
And she would never go anywhere without it.
Not for the most part.
The defendant had her phone when she went to the fry shack?
On March 5th, yes.
Yes. The morning after that, the defendant's phone had appeared to be missing?
Yes, that is correct.
So as a result, you and the defendant decided to ditch school that day to look for the phone on March 6th?
Again, correct.
Was it only you and the defendant?
That is correct.
So no one other than her best friend Avery could testify to this?
Objection, Your Honor, asked and answered. This point was already across earlier in the examination.
Response from the response from counsel.
I withdraw my question, Your Honor.
Thank you. Ask your next question.
The defendant's phone was an iPhone?
I don't. I actually don't know. I'm sorry.
Okay.
Oh wait, I apologize. Can I re-answer that? Yes, it was an iPhone.
All right. Were you aware that you could track iPhones using Find My iPhone program?
Yes, I realized that later, but I didn't think of that when we were searching for her phone.
No further questions, Your Honor.
Thank you. Any redirect from the defense?
Briefly, Your Honor. Ms. Perkins, does your relationship with Avery Becker have any effect on the truthfulness of your testimony in the court today?
Absolutely not. I'm only here to tell the truth.
Thank you. No further questions, Your Honor.
Witness may be excused.
Okay, I'm ready for the next witness.
Thank you. Will the defense call their next witness, please?
The defense calls Avery Becker.
Thank you, Ms. Becker. Please proceed.
Good morning. Please introduce yourself to the jury.
My name is Avery Becker.
Ms. Becker, we have heard that you are on trial today concerning the death of Mackenzie Brackman. Did you know Mr. Brackman?
Yes, I did know him.
How did you know him?
He was my high school mock trial coach.
And where did you go to school?
I attended Colorado High School.
Do you still go to school there?
No, I actually graduated last year.
Was Mr. Brackman your coach all 4 years of high school?
Yes, it was.
And you were on the high school mock trial team for all 4 years of high school?
Yes, it was.
What kind of roles did you play on the team?
For several years, I played the role of an attorney.
How would you describe your relationship with Mr. Brackman?
I would say it was strained.
In what way?
Well, you see, mock trial just came quite naturally to me. I worked hard, but never hard enough for Mr. Brackman. I admit I didn't always prepare as much as he wanted me to, and I didn't always focus at practice, but I thought I could do well enough without too much practice, just because it came so naturally to me.
Did you ever receive any recognition for your success at mock trial?
Yes, I actually won the Best Attorney Award at the regional tournament last year.
Miss Becker, you said you didn't work hard enough for Mr. Brackman. What do you base that on?
Oh, Mr. Brackman was a very demanding coach and required a lot out of everyone on the team. I probably didn't work hard enough for his high standards, and he would certainly criticize that.
Are you the only person on the team he treated like that?
Oh no, Mr. Brackman was hard on everyone. He was never good at handing out compliments, and he would get on all of us, really.
Do you remember any specific instances of conflict between you and Mr. Brackman?
Yes, there was a practice about a month before the regional tournament. I went to practice as usual, but Mr. Brackman was particularly hard on me. I started to respond, and Mr. Brackman just snapped. He demoted me to the B team, and he also changed my roles.
How did you take that?
Well, based on the awards I had won, I truly thought I deserved to be on the A team, so I tried to convince Mr. Brackman to let me back onto the A team.
Did you ever get back on the A team?
Yes, my friend Taylor Perkins was on the A team, and she quit. This caused Mr. Brackman to put me back onto the A team.
Did you go to regionals?
Yes, I did, and like I said, I did quite well. I won the Best Attorney Award, and I also won the award for the Best Closing Argument of the whole regional tournament.
Did that make Mr. Brackman happy?
Oh no, Mr. Brackman was upset that I had ad-libbed some of my closing.
Objection, talking about somebody else's feelings and mindset.
Response, Your Honor?
Response to that objection?
Your Honor, this witness is simply testifying under her own opinion, under the scope of Rules 403, based on her own rational opinion.
I'm going to overrule the objection. The witness may answer.
Let me ask that question just one more time, Ms. Becker. When you won the award for Best Closing Argument and Best Attorney, did that make Mr. Brackman happy?
No. Mr. Brackman was upset that I'd ad-libbed some of my closing and that I didn't follow the script he wrote. He told me I didn't even deserve the Best Attorney Award and that it was just lucky. He also told me I wouldn't even do well at the state competition.
Then what happened?
Well, I know this was wrong, but I argued with him and I told him he was a terrible coach. I regretted it, but I pridefully boasted that if it weren't for me and a few others on the A team, we wouldn't have even placed in regionals, much less have advanced to state.
What did you do after that?
Well, I left practice and then I did the stupidest thing of my life.
What did you do?
Well, I had a marker in my hand when I left practice. I thought it was a dry erase marker, but Mr. Brackman had this Porsche car and I wrote Worst Attorney Award right on the hood of his car.
Did you see Mr. Brackman after you did that?
Oh, yes, he walked up behind me after I finished and he saw what I had done.
How did he respond?
Oh, he said lots of things, but the one that was the hardest was that I was off the team.
What did you do after that?
Well, I went home after that and talked about the incident with my mum, and she suggested I go and apologise in the morning and knew that was the right thing to do.
Did you go and apologize?
Well, I tried. I went to his office the next day and asked his secretary if I could see him.
Were you able to see Mr. Brackman?
Unfortunately, no. He didn't want to see me, and I really wanted to apologise in person, but I realised I wasn't going to be able to do that.
Did you do anything else to express regret?
Yes, I texted him saying how sorry I was. I told him I would work to fix the paint on his car as well. I still thought it was a dry erase marker, so I told him it should just wipe right off.
How did he respond?
He just ignored me, and I was devastated. I mean, I never had the chance to talk to him ever again after that.
Now, Ms. Becker, I know this may be a little bit difficult, but let's talk about the day in question. March 6, 2020. Can you tell the jury what you did that day?
Yes, but I would have to start with the far. On March 5th, I'd gone to the mall in a fry shack with Taylor Perkins, and I think I actually left my phone there. So the first thing Taylor and I did on March 6th was go to look for my cell phone.
Did you find your phone?
No, and we spent all day looking for it at the mall and the fry shack, and we didn't find it.
Did you ever find your phone?
No, I must have left it at the fry shack, and the only other person near it was Alex Cifuentes.
What was your relationship with Miss Cifuentes like?
Oh, Alex and I weren't even friends. Also, Alex didn't want me back on the team because Alex wanted to be the best attorney.
Objection once again discussing somebody else's thoughts and feelings.
Response to that objection?
Your Honor, this is once again rationally based on the witness's perception. She and Alex Cifuentes were on the mock trial team together. They spent a lot of time together. This witness is simply making rational conclusions based upon what she saw and heard.
It's a close call, but I'll overrule the objection. The witness may answer.
So, Ms. Becker, you have heard the testimony of Alex Cifuentes today, claiming to have received a text from you saying you were going to commit a crime. How do you respond to that testimony?
Well, I didn't even have my phone, and I never texted Alex Cifuentes. That was a lie.
Now, the prosecution today has claimed that you had a motive to retaliate against Mr. Brackman. You have testified that you have no such motive. Do you know anyone outside of the mock trial team who may have had a reputation of conflict with Mr. Brackman?
Yes, Blair Rawlins, who
Why
was
do you say that?
was a classmate of ours at Colorado High School. I'm sorry.
Oh, you're good. Why do you say that?
Well, it was well known at school that Blair hated Mr. Brackman.
Objection once again discussing another person's thoughts and feelings outside of today's court.
Your Honor, this is not the witness speculating about any sort of thought or feeling. This is simply her testifying to a reputation that Blair Rowlands had among the school. This is something that would have been talked about and that Ms. Becker certainly has the knowledge about.
Your Honor, may I respond to that response? This reputation would also go under hearsay because it is other people's words trying to create a new reputation out of somebody else outside of court today.
And I'll overrule the objection. The witness may answer.
So, Ms. Becker, why do you say that Blair Rowlands had a reputation for conflict?
Well, it was well known at school that Blair hated Mr. Brackman. Mr. Brackman was a criminal defense lawyer, and he lost a case that got Blair's father sent to prison.
Is there any other connection that Blair Rowlands has to the circumstances of March 6, 2020 that you are aware of?
Yes, Blair was good friends with Alex Cifuentes.
Finally, Ms. Becker, I have to ask you this because of what the prosecution has charged. Did you break into Mr. Brackman's house on March 6, 2020?
No, ma'am. I didn't even know where he lived.
Did you go to Mr. Brackman's house on March 6, 2020?
Absolutely not. Again, I didn't know where he lived, and I was with Taylor all day.
Did you ever text anyone that you would get back at Mr. Brackman?
No, ma'am. I had lost my phone on March 5th, the day before. I couldn't have texted anyone on March 6th.
Miss Becker, did you kill Mr. Brackman?
No, I would never do anything like that to anyone. I mean, we might not have gotten along, but I would never even think of harming anyone, no matter what the reason.
Thank you. I have no further questions, Your Honor.
Thank you. Any cross-examination?
Yes, Your Honor. To begin, Ms. Becker, you were at school the day of Brackman's death, correct?
I'm sorry, did you ask if I was or I wasn't?
You were not at school, correct?
Oh no, I was with Taylor all day that day.
And Ms. Becker, you would say you and Mr. Brackman butted heads quite often, correct?
We would disagree about mock trial sometimes, yes.
In fact, you once believe that he hated you due to your talents and your easy ability to do mock trial, correct?
Like I said, we didn't always agree. We would disagree about mock trial for sure.
But you did believe he hated you due to this talent, correct?
I suppose he didn't always like me. We didn't always get along.
Exactly, you guys didn't always get along. And in fact, once Mr. Brackman called you lazy, correct?
He probably did call me that, yes, once in a while.
And you and Mr. Brackman once got in an argument about a month before regionals, correct?
That's correct, yes.
That night, you were moved to B team, correct?
Yes, I was.
And in your words, you believe the B team was full of losers. Is that correct?
I suppose so. It certainly wasn't the A team, which is the team I was usually on and team I was most familiar with.
When you attempted to move back to A team, you weren't able to by yourself, correct?
I suppose not, no.
In fact, it wasn't until your friend Taylor Perkins quit that you were put back on, correct?
That's correct, yes.
Moving to the practice after regionals, you and Mr. Brackman got into yet another argument. Isn't that correct?
I recall us disagreeing, yes.
That night, Mr. Brackman told you you didn't deserve the award you earned, correct?
I do remember him saying that, yes.
That angered you, right?
Well, I suppose it was a little upsetting. I mean, I did put in a lot of effort to win that award.
Exactly, you put a lot of effort, and when he said that statement to you, you stormed out of the room that day, right?
I suppose my feelings were hurt, so yes, I did leave.
With you, you had a marker in your hand, correct?
I thought it was a dry erase marker. Yes, I did. I'd been writing on the whiteboard before I left, so it was in my hand.
And after leaving, you wrote on Mr. Brackman's car, correct?
I did do that, and I very much regret it. I never should have done that.
And that same night, you went and told your mom that you and Brackman got into another argument, correct?
I was crying a lot that night. It was saddening for sure, yes.
And in that conversation, you told your mother that Brackman had once again gotten on to you for no reason, correct?
Like I said, I was crying and I was very upset that night. I probably said a lot of things. I was so crying and upset.
And in that conversation, you left out the part of you vandalizing the car, correct?
Like I said, I was crying. I was very upset. I might not have mentioned it, but I was so upset.
You told her everything leading up to the vandalism and you being removed from the team, but still left that out of the conversation, correct?
Objection, Your Honor, asked and answered.
Response?
I'm just trying to clarify that she had also discussed what happened after the incident.
I'll overrule the objection. The witness may answer.
And you had decided to leave out of the you had discussed with your mother that night about what had happened before the incident and after, but decided to leave that part out of the conversation, correct?
I'm trying to recall, I might not have mentioned it. I was really upset that night and I was crying quite hysterically, so I might not have said it.
And that same night, you told your mother that you would get back at Brackman, even if it was the last thing you did, correct?
I was crying and I was very upset. I might have said that, yes.
You did say those words though, correct?
I might have, yes. I was very upset.
No further questions, Your Honor.
Any redirect from the defense?
Yes, Your Honor.
I believe you have 1 minute left.
Thank you, Your Honor. Now, Ms. Becker, after this incident with Mr. Brackman, you just testified on cross that you were very upset. Did you do anything to express your regret to Mr. Brackman?
Oh, yes, I texted him saying how sorry I was. I couldn't have been more sorry. I offered to pay for the paint on his car. I felt horrible.
So you did not try to retaliate against him?
Absolutely not. I felt so bad for having done that.
Thank you. I have no further questions, Your Honor.
Thank you. The witness may step down.
Okay, I'm ready for closings.
The party's ready for closing?
Yes, Your Honor.
Yes, Your Honor.
Prosecution may proceed.
Desperation, location, confrontation. The defendant was desperate to get back at Mackenzie Brackman after he destroyed her mock trial career. Mrs. Becker was at Mr. Brackman's home the day of his death, confronting Mr. Brackman in her own ways, which ended with a high school mock trial coach dead on his own floor. Desperation, location, confrontation. Avery Becker is being charged with first-degree murder and second-degree burglary. The prosecution today has the duty to prove beyond a reasonable doubt that the defendant knowingly, intentionally, and unlawfully entered Mr. Brackman's home, and there Mr. Brackman was killed. We have proven today that this case was a burglary gone wrong. Desperation. Today, you heard from Alex Cifuentes, an ex-classmate and teammate of Miss Becker. Miss Cifuentes described how desperate Avery Becker was to get back at Mr. Brackman, even if it was the last thing she did. Miss Cifuentes displayed to you Exhibit 14 today, a copy of text messages between her and the defendant. In those messages, Miss Becker directly states, if he's mad about what I did to his car, wait until he sees what I'll do to his house. That'll show him. Location. Now, the day of Brackman's death was a school day, the same school day the defendant was absent from. Today, you also heard from Detective Markowitz, who displayed to you Exhibit 15. This cell phone data showed the movement of Miss Becker traveling from her home to Mr. Brackman's home on March 6, 2020, the day of Brackman's death. Confrontation. Mrs. Becker's verbal confrontations with Mr. Brackman didn't satisfy her. So she went on to more physical tactics, specifically vandalism. Vandalism of Mackenzie Brackman's car after an argument in front of the mock trial team, and vandalism of his own home after being removed from the team overall. Finally, today you also heard from Kyle Kuzak, who investigated the crime scene. They displayed to you a home ring video from Mr. Brackman's home of someone with the same height and build illegally entering Mr. Brackman's home through the back door and illegally leaving through the front. Desperation, location, confrontation. We have proven today that the defendant was desperate to get back at Mr. Brackman and went to confront Mr. Brackman at his own home. Miss Becker went to the home to trash it, but she ended Mr. Brackman's life in that moment. Members of the jury, we ask you to return the verdict of guilty. Thank you.
For the defense.
May I proceed, Your Honor?
Yes.
Don't judge a book by its cover. That's what we have asked of you today, members of the jury. And when you review the evidence of this case, you must conclude that the prosecution's cover has nothing to do with the contents. A criminal prosecution is supposed to be based on fact, but today the people are trying to sell you pure fiction. Don't buy it. They have failed in every respect to prove the guilt of our clients. And why? Because Avery Becker didn't kill anyone. Good morning, members of the jury. My name is Claire Ann Wind, and for the next couple of minutes, I will be reviewing the evidence to show you how the people have failed miserably to prove beyond a reasonable doubt that Avery Becker committed the crimes of second-degree burglary and first-degree murder. First, the elements of second-degree burglary. According to jury instruction number 8, the prosecution must prove that Avery Becker knowingly broke into Mackenzie Brackman's house with the intent to commit a crime known as criminal mischief. They did not prove this. The evidence showed that Avery Becker had never even been to Mr. Brackman's house. And that certainly wasn't our client you saw in the videos today. There is absolutely no evidence at the scene of the crime linking it to my client. Next, the elements of first-degree murder require the government to prove that Avery Becker committed the crime of second-degree burglary and killed Mr. Brackman during that burglary. They did not prove this. Not only had Ms. Becker never been to Mr. Brackman's house ever, and certainly not on March 6, 2020, the evidence showed that she was with Taylor Perkins the entire day. Avery Becker couldn't have killed anyone. Now, the only thing Avery Becker is guilty of is an immature response to an argument she had with Mr. Brackman. Ms. Becker acted out immediately after the argument, took what she thought was a dry erase marker, and drew on Mr. Brackman's car. But getting dismissed from a high school mock trial team is absolutely no motive to kill the coach. It is a wildly absurd theory from an investigation that never even looked into anyone else. Consider what this investigation relied on. Text messages that could have easily been faked from someone with a grudge against Ms. Becker. The incredibly average size of a defendant in a video that could have been anyone except Ms. Becker. And unreliable cell phone data from a phone Ms. Becker didn't even have with her. More fiction from this misleading book. The prosecution has made numerous assumptions about what happened on March 6, 2020. They assumed the intruder didn't know Mr. Brackman would be there. They assumed the intruder used a knife from inside the house. They assumed there was a struggle. They assumed it was my client because they assumed her phone was somewhere within miles of the Brackman home. But under the law, a prosecution for murder has to be supported with evidence beyond a reasonable doubt, not assumptions. Assumptions do not carry the burden of proof. Consider the testimony of Ms. Van Owen. She testified that a student named Blair Rollins had real motive to kill Mr. Brackman. But did the police investigate Rollins? No. Ms. Van Owen established that the police conducted a superficial investigation and never sought to find the real killer. The prosecution is simply trying to present you with something that is pure fiction, members of the jury. Let's call this case what it is. Simply a deceiving cover that promises you answers, but leaves you with only questions. The prosecution's case has left you scratching your head and wondering who could have possibly committed this crime, because it wasn't Avery Becker. Look at your instructions number 1 and 2. According to those instructions, the defense has to prove nothing. It's the prosecution which has the burden of proving beyond a reasonable doubt that Avery Becker committed the crimes of second-degree burglary and first-degree murder. They did not prove this, members of the jury. And that is exactly why we are asking you today to find Avery Becker not guilty and send a message to criminal investigations that they need to go out and find the person who actually committed this crime so that justice can be done for Mackenzie Brackman. Thank you.
Thank you. Any rebuttal from the prosecution?
Yes, Your Honor.
I believe you have 2 minutes remaining.
My timer shows 1 minute and 7 seconds remaining.
Thank you.
The defense just stood up and told you not to judge a book by its cover, which is completely accurate. Yet, they have just repainted their cover for your view. We today, as the prosecution, have shown the text messages of Avery Becker, which directly states her plan of entering Mr. Brackman's home to show him and prove her point. Ms. Beck, all we need to prove today is that Ms. Becker intended to break into Mr. Brackman's home, which we have done, and that Ms. Becker, while there, had killed Mr. Brackman, which we have done. We have shown Ms. Becker's movement from her own home to Mr. Brackman's home the day of his death. We have shown someone of the same height and build entering the home and leaving it at the same time. We ask you to find Ms. Becker guilty. Thank you.
Thank you. The court will be adjourned. Everybody breathe. We'll give Mr. Nolan some time to complete his scoring.